Just another smackdown of Gary Gensler and the SEC, and this was a foregone conclusion because basically the SEC was asking the judge for an early appeal, but we have this trial that needs to take place for Brad Garlinghouse and Chris Larson, and so an interlocutory appeal is usually done when there's not a trial left to do.
This content is brought to you by Link2, which makes private equity investment easy. Link2 is a great platform that allows you to get equity in companies before they go public, before they do an IPO. Within their portfolio includes crypto companies, AI companies, and fintech companies. Some of the crypto companies you may recognize include Circle, Ripple, Chainalysis, Ledger, Dapper Labs, and many more. If you'd like to learn more about Link2, please visit the link in the description.
Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me is attorney John Deaton. John, great to have you back on.
Thanks, Tony. Always a pleasure to be with you, my friend.
Yeah, it was great seeing you at the Ripple Proper Party. It
was fun.
Yeah, but it was certainly fun.
It was fun. It was amazing to meet everybody.
For sure. All right. So, John, yesterday we got news that Judge Torres denied the SEC's appeal attempt of the Ripple ruling. Tell us about that and the details around it.
Yeah, well, it was just another smackdown of Gary Gensler and the SEC, and this was a foregone conclusion because basically the SEC was asking the judge for an early appeal, but we have this trial that needs to take place for Brad Garlinghouse and Chris Larson. And so an interlocutory appeal is usually done when there's not a trial left to do. But they still ask permission. And I had predicted that she was going to allow them to file the motion. You first have to ask permission. Hey, judge, can I file a motion? And then she says yes or no. And if she says yes, you file it. And then she gives you the answer. And I said, of course, she's going to let them file it, and then she's going to use that opportunity to really solidify her first decision. It's not like she's going to change her mind and go, yeah, I got it wrong, right? After spending 6 months writing that order, I got it wrong, guys, you're right. No. So it's going to really allow her to explain it. And after her summary judgment ruling, and part of the basis for the early appeal request was that Judge Rakoff in the Terraform case, where he said, I'm not going to follow the line of reasoning that was in the Ripple case. Well, a lot of people, especially the Bitcoin maxis out there, everybody was jumping on it. Oh, the Rakoff decision is inconsistent with her decision. And this was a bad mistake of the SEC, Tony, because it gave her an opportunity. When a judge gives one ruling, you and I could debate it, right? Well, did she mean this when she said ABC? And you could say, John, I don't read it to mean that. And I could say, well, I read it to read this. And we could debate that, you and me. But when the judge says, well, let me tell you what I meant. Now there's no debate. So before this ruling we got last night, her decision was a little up in debate. The crypto world, like Coinbase, was saying, look, she said that XRP sold on an exchange isn't a security. Therefore, all tokens sold on exchanges are not securities, right? And then the Rakoff decision comes, and he says, well, it's possible that in this case, in the Terraform case, that Luna was a security, and everybody thought it was inconsistent. And now Judge Torres said, no, it's not inconsistent. She even said she basically would have done what Rakoff did. But what she did was limit it to XRP. And she said, I never said that it was impossible for a token to be a security sold on an exchange. I never said that. Right. All I said was that in this case, XRP sold on exchanges, even if sold by Ripple, didn't meet the Howey test because of the facts and circumstances of this case. And she went ahead and said in the Rakoff decision, she said, yeah, he was supposed to assume. When you read the complaint in that case, it literally says that their marketing efforts of Do Kwon was so massive that it told everyone in the world that if you buy Luna and UST, we're going to use that money. It's going to go in the ecosystem and it's going to build more and it's going to raise the price, and that everybody was in it together. Like, they literally said those things. And
Right.
so Rakoff, none of that is Ripple, right? In the SEC Ripple case, they were saying, look, Chris Larson tweeted in 2014, right? And they were like, so what? I never saw that tweet. And they were like, hey, look, Ripple gave a brochure to 100 people in 2014. That the judge said there's no evidence that reached Tony, that reached John,
Never seen that.
the general public. We don't know that. And so she then just really took the SEC to staff. And she did to school. There's a footnote in it, Tony, where she even says, look, let me give you a hypothetical. She says, assume there's a person and they're on an exchange, say it's Coinbase, and they notice that XRP is going up. And they decide to buy XRP right then and there because they think it's going to go, it's up 4%. They think it's going to go up another 4%, right? So they buy XRP and they're expecting a profit. So what? That doesn't mean they're expecting a profit from Ripple's efforts. Mm-hmm. They're just expecting a profit. And that smacks Gary Gensler down because just as good as anyone, he gets up there and says, people are expecting profits. People are expecting profits, right?
Yeah,
and so she smacked it down, man.
Yeah, and if you look at the details about how market makers work, in addition to the market has moved with Bitcoin rallies, guess what? All start popping off too. That has nothing to do with the individuals involved in certain coins and whatever work they're doing. It's just the market's moving. It could go up based on BlackRock filing for Bitcoin spot ETF because everybody's like, oh, I better get in.
Absolutely. And the judge cited again, one of the facts that she relied on, it was the fact that many people that bought XRP for the first time on exchanges never knew of Ripple. And so that was the affidavits that we submitted that, even in this second decision, we had an impact on it because of the evidence. So it was a really good decision. The SEC didn't come close to meeting the standard for an interlocutory appeal, and she completely knocked it down. And then she gave a trial schedule at the very last page of her decision. She basically said on December 4th, that's coming up, right? That's less than 60 days, man. The SEC and Ripple must submit motions in limine. And motions in limine, for your viewers and yourself, are when a party asks the judge to maybe exclude some evidence. You know what I mean? If there's something inflammatory, I gave an example on my live cast where there's a document against one of the companies I sue where one of their executives wrote, my answer to the asbestos problem is this: if you made a good living from asbestos, you might as well die from it. Right? Now, that's a pretty aggravating document. And if you're on the jury and I show you that and I say, this is what the company thought of my client's life, right? So cavalier about it. Well, that company always files a motion in limine before the case starts, asking the judge to exclude that. Judge, don't let Deaton bring that document to the jury, right? Because it's going to inflame them. So we could expect the SEC to maybe say, Judge, we want you to exclude any reference to the Hinman speech in this case. we want you to exclude Bill Hinman as a witness. He shouldn't be called as a witness. Those are the kinds of things that we might get to see here real soon.
So, John, could that whole trial and all these things be thrown out if the SEC says, hey, you know what? We're taking so many L's here. Let's go settle with Ripple in some way. Is that an option as well?
Oh, absolutely. They don't even have to settle with Ripple. They could just dismiss. They could just simply say, we believe we're going to lose. We're not going to be able to convince a jury that Brad and Chris were reckless. It's not worth our time. We got to fight Coinbase and all these other people. So we're just going to dismiss the case. And then they could talk settlement, or they would go into the next hearing before Judge Torres and argue over what is the appropriate level, right? Ripple's going to try to reduce that $770 million, right? They're going to try to exclude ODL cells. They're going to try to take legitimate expenses, business expenses. That wasn't 700 million of profit, right? And so their employees' salaries and bonuses and benefits and travel expenses, things that money went to, should be reduced. So it's just profits that they're taking. So they would fight over that. But yes, the SEC could be talking settlement right now. I'm not saying they are,
sure,
right? But they could, and they don't want to try the case. So I don't think a trial is going to happen.
Okay, so that's your prediction, that a trial is not going to happen.
Yeah, I don't think a trial is going to happen. They're going to lose, and do they really want all that Hinman stuff and the drama of a trial? And I mean, a trial in this case, Tony, would take a month. You know what I mean? Ripple would want to call Hinman, Valerie S., Amy Starr, Hester Purse. I mean, I'm just naming names, right?
Oh, sure.
They might want to call John Deaton. Who knows?
Jay Clayton? Jay Clayton, maybe?
I mean, it's going to be a big, long, lengthy, very, very expensive trial. And if your chances are slim to none, why do that, right? Now, if they weren't fighting Coinbase and Binance and doing all the other things, maybe it's worth it. But don't you need those resources to fight the other cases?
Yeah.
And so that's what I mean, is that I don't think there'll be a trial, but I could be wrong.
Now, John, we saw the folks at LBRY also filed an appeal, I think, using the Ripple case law to back them.
Yep.
Any thoughts on that?
Well, I think that this Ripple case is less likely to get to the Supreme Court now, because the judge in this decision really, really went out of her way to talk about the facts of the case. In the LBRY case, there's a chance that the Supreme Court could eventually reach the major questions doctrine. Whereas in the Ripple case, it's out there, and in the Coinbase, it's out there. But a lot of people were talking about Ripple tests. It could end up being LBRY tests. You know what I mean? Not so much that the Howey test would be renewed. It would just simply be that Howey doesn't apply to asset sales on exchanges. You know what I mean? That's just a blind bid ask. It's an asset. It's not an investment contract. And so it could be something like that. Or it could really smack the SEC completely down and say that they just don't have jurisdiction over crypto, period. Unless there's a written contract.
Yeah, and it seems like Congress right now, in the House at least, they're trying to push some bills through. So maybe the Congress recognizes the urgency, at least in the House, that this thing could fall apart for the SEC, because they lost to Grayscale as well. And it seems like the judges, both in the Binance and Coinbase lawsuits, are just been calling out the SEC and their nonsense. What are your thoughts on how the SEC versus Coinbase has been going?
Well, I'm hoping, and I've tweeted out that I think that there's a legitimate chance that, Coinbase has a motion to dismiss. For your viewers, Tony, most of the time in a motion to dismiss, I would say the chances of success are between 1% and 9%. And it just doesn't happen. In the Coinbase case, I've got it up there at the 50% range now. Like there's a 50% chance that they could be successful, because the judge could say, that an exchange where the buyer doesn't know the seller and there's no written contracts involved, and they can't rely on someone you don't know, right? That those are not subject to securities laws, to the Howey test. Those are not subject to the Howey test, that they could never satisfy Howey, because you don't know, that third prong would never be satisfied, relying on the efforts of someone else, except in rare circumstances. And so there's a chance that could happen. The SEC's opposition to Coinbase's motion to dismiss was terrible. And so Coinbase has better lawyers for sure. And so again, it's not higher than 50%. So it's like flip a coin, which normally I wouldn't say that, but I do think it's possible now.
I know in the Binance case, the judge has blocked the SEC from doing further discovery, if I'm not mistaken. And I saw some folks in the industry started filing amicus briefs on behalf of Binance in that lawsuit. Any thoughts on what's happening there?
Yeah, the Binance case is always harder, because when there's allegations of fraud. Right. And when there's allegations of fraud, that's always more tougher. I'm not surprised that people are filing amicus briefs. I think there's going to be many more amicus briefs. But that the fraud distinguishes it from, and I'm not saying the fraud is correct, I'm just saying it's alleged. It distinguishes it from the Coinbase one. You know what I mean?
Oh yeah, they're definitely very different cases. And I don't think you and I spoke since the Grayscale ruling. I mean, the three judges just taking the SEC to the woodshed. What are your thoughts on that ruling?
On which one?
The Grayscale ruling on
the Grayscale ruling is I'm going to pat myself on the back, because I predicted that one. I predicted, I even before they filed, I said somebody needs to sue the SEC for arbitrary and capricious, because you can't justify a futures in a leveraged futures,
right,
and not a spot. You know what I mean? And so you can't justify it. You can manipulate each one equally, is what I'm saying. And so you can't treat them differently. And so I think that we're going to see spot ETF and within 6 months. Not going to be before the end of the year, but the question is, will it be first quarter or second quarter of next year?
And then there was news that came out this morning of the SEC enforcement director, Gurwal, if I'm saying his name correctly, possibly being under investigation with connections to Bob Menendez. It just seems like things are not going well for the SEC overall, and this looks like it could be pretty bad, having the enforcement director being caught up in things like that.
Well, listen, I think they're all I can't comment on that, because I don't have any facts. I would say I'm not surprised, because he's a politician and he got the position he got. He used to be the attorney general from New Jersey, and now he's the SEC enforcement director. But when he misled Congress under oath, when he was asked direct question whether or not the Hinman speech had been cleared by SEC ethics, he lied. As far as I'm concerned, he lied. The more softer way of saying it was he misled, right, Congress, by saying that he can't answer that question because the speech was subject to litigation. Whether or not the ethics had approved it was not subject to litigation. The overall speech was subject to some litigation. So he could have answered that question, but he chose not to. And to me, that lacks integrity and that lacks honor. And so I wouldn't be one bit surprised if he's entangled in some nonsense.
Final question here for you, John, because I know you got to go.
Yep.
Are you planning to be be involved in any other cases like you did with the Ripple case on behalf of the XRP holders, or you're kind of just watching and waiting?
Well, I'm if the Coinbase case, if Coinbase loses their motion to dismiss and it goes to summary judgment, I'll be filing an amicus brief on behalf of Coinbase customers. I have about 4,000, almost 5,000 of them signed up to be amicus, and I may be involved in a case. We'll see here in the future. I won't say anything yet, but let's see how the SEC responds when they not only have to fight me on Twitter, but fight me really in court.
Right. Well, John, man, thank you as always. And I know we didn't get time to hang out a lot at the proper party because it was so many people. But next time we have to do a steak dinner.
Absolutely, man. Absolutely. We're going to talk soon, brother. I love you, and I'll talk to you later, okay?
Thanks, John. Take care.